The Law Library at Stateville Correctional Center in Illinois opens at 8 a.m. By 8:05, every seat is taken. 15 men hunched over legal texts, typing on ancient computers that have no internet access, scribbling notes on yellow legal pads purchased from commissary at prices 3 times what they cost outside. These aren't lawyers visiting clients. These are inmates, some serving decades, some serving life, who've taught themselves enough law to file appeals, win motions, occasionally overturn their own convictions, or reduce their sentences. This is the Prison Law Library, one of the few places in the American criminal justice system where hope isn't completely dead, where inmates with nothing but time can transform that time into legal expertise that sometimes, just sometimes, opens the door they thought was locked forever. The right to a law library in prisons was established by the Supreme Court in 1977 in Bounds v. Smith, which held that prisons must provide inmates with adequate law libraries or adequate assistance from persons trained in the law. The reasoning was straightforward. If you're going to incarcerate someone, you can't also deny them the ability to challenge that incarceration. Most prisons chose libraries over hiring legal staff because libraries are cheaper. But what the court required and what prisons actually provide often diverge significantly. Many prison law libraries are underfunded, understocked, staffed by overworked librarians who aren't lawyers, and filled with outdated materials that don't reflect current legal standards. At Stateville, the library has approximately 2,000 legal volumes, federal and state case reporters, statutes, legal encyclopedias, form books that show how to draft motions and briefs. The books are decades old in many cases, 2005 editions of texts that have been updated multiple times since. But for inmates who have nothing, these outdated books are everything. They're the only tools available to challenge convictions, file habeas petitions, argue for sentence reductions, and some inmates become remarkably skilled at using them. James Morrison has been at Stateville since 1995, serving life without parole for a murder he committed during a robbery when he was 23. He's now 52. For the first decade of his sentence, he did nothing productive, lifted weights, watched TV, counted days that would never end, because life without parole means exactly that. You die in prison. But in 2005, another inmate suggested he learn law, not to free himself. His conviction was solid, his guilt unquestioned, but to help others whose cases might have issues worth appealing. James started reading, began with basic criminal procedure texts that explained how the legal system works, moved to case law, reading hundreds of appellate decisions to understand how courts analyze issues, taught himself legal writing by copying the structure of successful motions he found in the library. By 2008, he was drafting appeals for other inmates. By 2010, he was winning some of them. Not many. The success rate in post-conviction litigation is low, but enough that his reputation spread. Inmates sought him out. Guards who initially dismissed him as a jailhouse lawyer, playing pretend, began to respect his knowledge. The term jailhouse lawyer carries contempt from many attorneys and judges. It suggests amateur hour, inmates with minimal education, pretending to understand complex legal doctrine. But some jailhouse lawyers develop expertise that rivals or exceeds that of overworked public defenders who barely have time to read case files before court appearances. James Morrison reads 8 hours a day, 6 days a week, has done so for 15 years. That's over 25,000 hours of focused legal study. Most attorneys don't accumulate that much focused reading in their entire careers. His lack of formal legal education is offset by sheer volume of time and intensity of focus that professional lawyers, with their multiple cases and administrative burdens, can never match. The inmates who use the library fall into several categories. Some, like James, are helping others because they can't help themselves. Others are fighting their own cases with desperation that comes from facing decades behind bars. A few are gaming the system, filing frivolous motions to delay transfers or create paperwork that might buy them time. The library can't help the latter group. Courts recognize and dismiss frivolous filings quickly. But for inmates with legitimate issues, the library is their only chance. Consider Michael Torres, serving 30 years for drug trafficking. His conviction in 2012 was based partly on testimony from a confidential informant who claimed to have witnessed Michael receiving drugs from a supplier. Michael maintained innocence, but his trial attorney was incompetent, barely cross-examined the informant, presented no defense witnesses. Michael's direct appeal failed. Appellate courts don't usually overturn jury verdicts based on credibility determinations. But in 2018, working in the Stateville Library, Michael found a newspaper article about his case's prosecutor. The prosecutor had been disbarred in 2016 for misconduct in multiple cases, including withholding evidence favorable to defendants. Michael drafted a habeas petition, arguing that his prosecutor had likely withheld evidence in his case too. He requested discovery to examine the prosecutor's file. The petition was well written, cited relevant precedent, made a plausible argument. The court granted discovery. And in the prosecutor's file, they found notes indicating the confidential informant had initially told police a different story that didn't implicate Michael. This was Brady material, evidence favorable to the defense that should have been disclosed. The prosecutor had buried it. Michael's conviction was overturned in 2019. He'd served 7 years of an unjust sentence but was released. Without the law library, he'd still be inside. These victories are rare, but not unique. Every year, dozens of inmates across the country successfully challenge their convictions using legal research conducted in prison libraries. Some find prosecutorial misconduct. Others discover their trial attorneys provided ineffective assistance of counsel. A few identify scientific evidence that's been debunked: bite mark analysis, hair microscopy, questionable forensics that sent innocent people to prison. The library gives them the tools to prove it, but the library also serves another function that's less dramatic but equally important. It teaches inmates that the system is comprehensible. That law isn't magic wielded by judges and attorneys, but a structure with rules that can be learned and used. This knowledge is empowering, even when it doesn't lead to release. Inmates who understand why they're incarcerated, what legal procedures were followed, what rights they have. These inmates are less likely to view their imprisonment as pure, arbitrary oppression. They're more likely to accept their situation, even while working to change it. This might seem like a small thing, but in an environment where despair and rage are default states, anything that provides agency and understanding improves mental health and reduces institutional violence. The opposition to prison law libraries comes from several directions. Budget hawks argue they're expensive and rarely produce meaningful results. Law and order advocates claim inmates shouldn't get free legal resources when victims get nothing. Some prosecutors and judges view jailhouse lawyers as nuisances who clog courts with frivolous motions. There's truth in some objections. Prison libraries are expensive, some filings are frivolous, and resources are limited. But the alternative is denying incarcerated people any ability to challenge potential injustices, which violates basic principles of due process that the Supreme Court recognized in bounds. The future of prison law libraries is uncertain. Technology could democratize access. Tablets loaded with legal databases could provide better research tools than ancient books. But many prisons ban internet access even for legal research, fearing inmates will use it for other purposes. Some facilities are eliminating physical libraries entirely, replacing them with limited computer terminals. This saves space and money, but reduces the collaborative learning that happens when inmates work together in library spaces. James Morrison learned law, partly from books, but also from conversations with other jailhouse lawyers who shared insights and strategies. Isolated terminals can't replicate that. The emotional toll on inmates who become jailhouse lawyers is significant. James has worked on over 300 cases. He's won perhaps 20. That's a 93% failure rate. Most inmates he helps will die in prison, despite his efforts. The hope he provides is usually false hope. But he continues, because the alternative, doing nothing, accepting that all these men are beyond help, is psychologically unbearable for him. The library gives him purpose. The law gives him a way to fight, even though he can't fight for himself. And occasionally, very occasionally, he frees someone. And that makes the hundreds of failures worth enduring. On a typical day at the Stateville Library, you'll find James at his usual table, surrounded by stacks of case reporters. Younger inmates approach him with questions. He explains procedure, suggests research strategies, reviews their draft motions. He's not paid for this work. Prison wages are pennies per hour, and library legal assistance isn't compensated. He does it because it's the only thing that makes his life sentence feel like something other than waiting to die. The library isn't just a room with books. It's a space where time, the primary currency of prison life, can be converted into something meaningful, where lifers can become experts, where the powerless can access tools of the powerful, even if those tools rarely work. If you want to explore more stories about how inmates survive and find purpose in long-term incarceration, subscribe to Prison Diaries. Because the Prison Law Library represents something fundamental about human nature. The drive to understand, to learn, to fight, even when fighting seems pointless. And sometimes, just sometimes, that fight succeeds in ways that change lives.